Hello, I'm Advocate Nikita Pandit and I will be speaking about the licensing in copyright in India, and you're watching Legal Bytes. The main objective of this video is to understand how the owner of different works, that is the copyright owner, can transfer his right by license as per the provisions of Indian Copyright Act 1957. Copyright is a transferable right. It can be sold, assigned, or even given on license. It can be bequeathed. It can also be transferred to the legal heirs or the representatives after the death of the copyright owner by the laws of succession or by will. License is a permission which is officially given to another person to do something that the owner does himself. Chapter 6 of the Copyright Act 1957 deals with the licenses. Section 30 of the Act lets the owner of the copyright of any work or the prospective owner of the future work or their agents to give the interest in the work on license to another person. Where the license is given for the work that may come into existence in future, the right is only transferred when that work actually comes into existence. If the person giving the right in the future work dies, then when the work becomes a reality, the legal representatives have the right to deal with the license as per the terms of the agreement, and they can collect the license fees. The application for the license of copyright is similar to that of assignment. License agreement must be in writing, and if it is not in writing, it is considered as invalid. The agreement must clearly specify which work is licensed, what are the rights, what are the liabilities, the time period for which the license is made, the area under which the license shall operate. Alterations can be done to the agreement if both the parties agree. If the license period is not given, it is considered as 5 years. If the territory of operation is not given, it is considered the entire territory of India. Now, if the licensee fails to utilize the license as per the terms of the agreement, a complaint can be made by the licensor to the appellate board, and the board can hold the inquiry for the same. The term of the copyright, as we have seen, it is the lifetime of the author and another 60 years after the death of the author. It may happen that the owner of the copyright may withhold the work from publishing or communicating it to the public. He may do it by not allowing the republishing, or he may himself not republish the work. He may not let the work be performed in public or broadcasted to public. Now, in such situations, any person can approach the appellate board under section 31, and the board gives an opportunity to the copyright owner to explain why he is withholding the work from public. If he does not have any valid explanation, then the complainant is allowed to communicate the work to public, and the same directions are given to the registrar. The appellate board decides the compensation to be paid to the copyright owner for parting with his rights temporarily. If the owner of the copyright work is dead or cannot be found, then anyone can apply for a license. Application is to be made to the appellate board. Now, before application, the applicant has to publish what he proposes in one daily newspaper in English language. Now, if the license is for translating the work of the owner, the publication of that proposal should also be made in that language in which it is to be translated. The copy of this advertisement is to be submitted along with the application of license. Now, if the appellate board is satisfied that the license is good, he directs the registrar to grant the license to the applicant when he pays the appropriate fee. The board also determines how much royalty is to be paid to the licensor by the licensee, and it is to be deposited by him in the public account of India or as per the directions of the appellate board. In case the work is not published by the reason of death of the owner or the author, The central government is empowered to make the legal heirs or representatives or executor to publish such work within a given time if such publication is of necessity for the purpose of national interest. If they fail to do so, the appellate board can give the license to the applicant who has applied for the license on payment of the decided royalty as per the appellate board. If the application is for compulsory license of the work which is to be published for the benefit of disabled, then the approval process is to be completed within a period of 2 months by inquiring if it is made in good faith. The definition of disabled can be found in the new Rights of Persons with Disabilities Act of 2016. In section 2S of that act, disability is when a person is having physical, mental, intellectual or sensory impairment or weakness. It causes an injury or a disease which causes hindrances with his interaction with others and prevents his equal participation because of that disability. There are certain provisions for the licenses for the broadcasting organization. Broadcast as per section 2DD means communicating the work to the public by wireless diffusion or by wire, where the signs, sounds and visual images reach to the people and the people are able to perceive these works by their senses, that is, they can see it or hear it. When any organization provides such services, they are called as broadcasting organizations. When they want to communicate the work by licenses, they have to give the notice beforehand about what they want to publish and for how long they will be publishing it. The royalty is decided by the appellate board. The rates of royalties differ from medium to medium. For TV, it is different. For radio, it is different. Now, except in case of performances, it is must to give the credit to the authors, owners and the main performers of the copyright work on that broadcast, and their names should appear on that work. According to section 2Q of the Act, the performance is any presentation of the work by visual or acoustic means being heard, which is live by the performers like actors, singers, acrobats, jugglers and others, and this definition is given in section 2QQ of the Copyright Act. The broadcasters should not make unnecessary changes to the work without the permission of the copyright owners. The broadcasting organizations have the responsibility to keep all the accounts of the use of the work and also allow inspection by the licensor whenever required. There is an example of Asia Industrial Technologies versus Ambiance Space Sellers. The defendants operated the cable television network in India. On their cable network, the original broadcast had one advertisement and it was interrupted. A local advertisement was shown instead of that. Defendants claimed that they had a right to do that, and the broadcast consisted of works from British Virgin Island and Hong Kong who were not the members of Berne Convention, and so they did not have any protection. The court held that the show and the advertisement both consisted one work and it cannot be separated. It was directed that the defendant shall not change the work and put their own advertisements. A leave was taken to appeal to the Supreme Court, but it was denied. There is one more case, Tips Industries versus Wink Music. Tips is a music label having copyrights in various works. They granted a license to Wink for the music they had copyrighted. On expiry, Wink wanted to renew it, but Tips refused. Wink filed a plaint stating that they had the exclusive license. The court held that Wink had infringed the work as they let the people download that music for a fee by streaming it on their website or application. Now, section 31D that time did not include internet streaming in the definition of broadcast. However, court held that internet streaming should also be included in the broadcast, though it is not clearly mentioned in the statute. And Wink had infringed the rights of the tip, and if wing continued, it would cause irreparable damage and loss to the revenue of tips. There are another provisions for translation of works from one language to another. After the 7 years of publication of the work, any person can apply for the license to translate the literary work or dramatic work. After 1995 amendment, literary work also includes computer programs and databases. Now, dramatic work, as we have seen before, it includes reciting, choreography, dumb show, acting. It does not include cinematographic work. So, if the work is to be translated from a foreign language to Indian language for education, scholarship, or research work, the application can be made for a license of such work after 3 years from publication, unlike the 7 years in case of dramatic works. The application has to give an estimate of the price at which they will be selling the translated work. Such translated work cannot be exported, and it should be clearly mentioned on the translated copy that it is to be distributed only in India, except the export by the government for certain purposes such as education, teaching, or it is given to the Indian residents gone outside, or if at all the government permits. Now, if the copies of some works is not available in India or are not sold in India for at least 6 months or not given for a reasonable price which the comparable works offer, anyone can apply for the license for those literary, dramatic, artistic and scientific works for reproducing, publishing or translating such work. When such license is granted, this too should not be used for exporting. This can only be done where the work is already published or translated, but the language is not understood in India. Section 32B provides the scenarios where the license can be terminated or cancelled. In case of production and publication of translation, if after license is given, the licensee, the owner of the copyright, does not come up with the similar translation at the reasonable price, then as like that of the comparable work, the license terminates by a 3 months notice period. The same is in the case of the reproduction of the translated work. Now, these are certain important provisions which we have to remember in case of licensing the copyright work. Thank you.